My name is Frank Musica, and I'm one of the risk management consultants here at Victor. I've been involved in both the AIA Contract Documents Committee and the Engineers Joint Contract Documents Committee programs for decades. And in addition, each year I look at 600 to 700 contracts submitted by our policyholders. And one of the issues that routinely arises is contractually assumed indemnification obligations or defense and indemnification obligations. And they often exceed a policyholder's normal liability in the performance of professional services, and therefore the policyholder's professional liability insurance coverage. So here's the agenda for our short time today. Note that we will only be dealing with indemnities in professional service contracts. There are many other situations where the business practice of providing professional services has to address contractual indemnities. And of course, in joint venture agreements, integrated project delivery arrangements, and even prime sub-consultant agreements, there are often contractual indemnity obligations that either restate or extend beyond normal legal liability. We do not have time to address them today. Now, I need to give you the disclaimer. As an insurance company, we cannot offer and we are not providing legal advice. As you should know, with all contractual issues, the applicable law can change the meaning and effect of a contractual commitment. And with indemnification provisions, there's a real need to parse out the meaning of each word in the provision. How each jurisdiction addresses the specific wording of a provision, such as an indemnification obligation, can differ significantly. But here is what we're going to cover in a quick overview of the exposure and ways of mitigating exposures. And the handout will provide you with much to consider as you go forward in practice. We might not cover everything in great detail, but you will have the information for future reference. And one other thing, nothing in a contract has to be fair. When you establish a contractual relationship, you are in essence creating private law between the parties to the contract. There can be a lot of flexibility in what a contract requires. Okay, let's get started with some background. Contractual indemnity provisions started to be added to professional service contracts back in the 1980s. If you were in practice back then, as I was, you might remember that period by what Michael Douglas as Gordon Gekko said in the movie Wall Street, which was, greed is good. It was a time of high interest rates, rampant inflation, and greed. With construction loans having 20% or so interest rates, every developer wanted the project built immediately to minimize the financing costs. So shoddy construction was the rule, and therefore claims happened. More than twice the rate that claims have been happening in the last decade. And every problem cost a lot of money because as every day went by, financing and construction costs soared. So insurance rates soared. And many firms simply stopped paying for insurance because clients wanted to be able to recover quickly, and from whatever pools of money they could, they added contractual indemnity obligations to contracts. Often the provisions just said something like, you will pay me for any additional cost to me caused by the project. They were usually very broad, and they did not have to have negligent performance alleged or proven to allow the client to recover. Now, there were attempts to fight back. In 1982, the EJCDC added the first standard indemnification provisions to a contract. It limited the obligation to actual damages caused by negligent performance. The AIA added its first in a professional services contract in 2007. And I'll show you the current language of those standardized contracts later. Indemnification basically means making one party whole, either by paying on behalf of that party or reimbursing or indemnifying the party. And one of the first drafting questions we are often asked is whether there is a difference between a clause that provides for indemnification versus one that uses the phrase indemnify and hold harmless. The answer to the above question is basically no, although, as always, there is some differentiation at the state law level, but both contemplate third-party liability situations. Note the underlying language in this slide. That is where the danger is really generated. The express agreement, the private law between the parties. Now, you have probably seen simple but very broad obligations, or just pages and pages of specific indemnity obligations, and that can be overwhelming. There are dangers in both, and both take careful reading by you and by your legal advisor. Now, tort law liability is basically common law liability based on equity. But sometimes there is an implied contractual obligation to indemnify. For instance, this happens when one party has a higher duty than design firms usually have. Perhaps a fiduciary, someone who has control over another party's finances, may have an implied contractual obligation to indemnify the party for any losses. But it is the express contract provisions that create the problem for design firms and others in the construction industry. Indemnification provisions are divided into broad, intermediate, and limited forms. I cannot go into the detail now, but it is the limited form where the party providing the indemnification is stating, I take responsibility for the harm to you to the extent harm is caused by my negligence. You, of course, also can take responsibility for your gross negligence, your willful and wanton acts, for violating the law, or for other things for which you might be legally responsible. Those, of course, go beyond your liability in the performance of professional services. They are basically business risks. Now, professional liability, and therefore professional liability insurance, is based on tort law. And tort law states that a party is responsible for damages the party causes. That is the basis of the common law concepts of indemnity, paying to correct harm, and contribution, paying to correct only that portion of harm caused. In the United States, there is great freedom to contract, as long as it's not for an illegal activity. And that freedom means you have to negotiate to protect your interests and to keep contractual provisions in line with normal legal liability. By the way, if you use an AIA or an HACCC contract form, that is what happens. That is why those contracts are so carefully worded. They track your contractual liability with your normal legal liability. Contractual indemnity is different from common law or tort law indemnity that requires a party at fault to restore a party harmed by the wrongful act to its original position. Indemnity provisions in contracts allocate the risk of the business transactions between the two parties by obligating one party to pay the expenses incurred by the other party under certain circumstances. Again, fairness is not an issue. Those circumstances under contract might be limited by state law, but usually they're not. There's a lot of leeway. Later, we will look at the dangers of the defense obligation, which is entirely different from a normal indemnification obligation. I always need to remind firms that when they agree in a contract, what they agree to in a contract has no impact on their professional liability insurance coverage. If you have coverage, your insurance policy is a contract between you and the carrier, and it only covers what the terms and conditions of the policy says it covers. In a professional liability insurance policy, that is your liability in the performance of professional services, which is what this highlighted statement defines. Now, indemnity provisions can address many perils. That's why in many cases they're extremely long. The many perils can include things within your control, your business risk, and things outside of your control, such as delays caused by COVID-19 problems, for example, or harm resulting from climate change, or from the incompetence of the construction provider. And you cannot be insured for all the perils, although through your many policies, your CGL policy, your cyber liability, your employer liability, employment practices insurance, and of course your professional liability insurance, you can be covered for many of them. Somewhere in a long list of perils in an indemnification form should be your failure to meet the standard of care for the professional services you perform. That's what you're covered for. It is the upfront defense obligation that can create major business risks. In some situations, with some kinds of insurance, an upfront defense obligation might be provided by your coverage, but that is not the case with professional liability insurance. In any third-party claim which you are required to defend, your interests and those of your client are rarely in concert. It is unusual that a claim against your client would be based solely upon allegations of professional negligence by you as the contractual indemnitor. Those allegations must be proven before a professional liability insurance carrier will cover any client defense costs as damages through an indemnification agreement. There might be some limited exceptions to that, but it is never automatically providing a defense to your client. Now, some of the situations that may arise is it might be in the best interest of you as a policyholder or your insured to defend the client to maintain control of the defense, or to strategically present a united defense with your client if your interests are the same, or lastly, to defend both the policyholder and the client because there's an unequivocal case of liability against the policyholder. So in those situations, there might be a defense of your client as part of your defense, but it's never automatic. There is never an automatic defense provided to anyone other than the policyholder. And remember, I briefly mentioned broad, intermediate, and limited forms of indemnification provisions. Agreeing to a broad or intermediate obligation could mean not only that you're defending the client, but you take on paying for the cost caused by others. So your normal professional liability is that you are only responsible for the harm you caused and not for the harm caused by others, other than, of course, your subconsultants, because you're vicariously liable for harm caused by subconsultants. And this is why you should never assume a contractually assumed indemnity or defense and indemnity obligation. I mean, it's clear. Do not count on your instincts, your knowledge of the law, or the opinion of your insurance provider in reviewing them. Contractual provisions are governed by statutory and case law in each of the 56 U.S. state and territorial jurisdictions and the 500 plus sovereign Native American tribal areas. As such, design professionals should continue to avoid the inclusion of an indemnity provision in their contracts, because if you do that, common law indemnification would apply, and that follows the actual harm caused by your negligence. If you cannot avoid a contractual obligation, the provision should specifically exclude any duty to defend when the indemnity is related to a third-party claim that asks for damages because of possible deficient performance by the design professional, because there could be many other causes of that harm in addition to the possible cause of harm by your services. And remember, contractual liability insurance will not cover a contractual defense obligation. If design professionals cannot avoid the inclusion of any indemnification provision in their contracts and cannot specifically exclude a duty to defend, They should include a provision making it clear that the obligation to pay their proportionate share of defense costs shall not occur until there has been a final determination of the underlying matter. And we'll show you that in some examples. Otherwise, as a design professional, you would have to pay the cost of the defense and then attempt to seek reimbursement from your client if you were found not to have any liability, or if you were found to have paid more than your share of defense costs when you do have some liability. And recovering from a client can be costly for any number of reasons. Now, depending on the specific language and the specific state statutory and case law, the duty to defend can differ. It can apply to a narrow obligation or an extremely broad obligation. Now, realistically, even in a broad defense obligation, there'll be some limits. If you have a client such as Google, it does not really want to place its fate in the hands of a small design firm. But however they are worded, contractual defense obligations can create problems and could destroy your financial viability. So here is what a statement of indemnity that is compatible with professional liability insurance and your normal tort law liability in the performance of professional services could include. If you look at the language of 3, it talks about recoverable under applicable law. And this might be statutory, but usually is whether the costs are defined as damages under case law. And if you wonder what the definition of reasonable attorney's fees is, well, it's not defined, but is usually what a court considered fair, proper, or moderate under the circumstances. Reasonable is not a word you want to avoid. It actually can help in any negotiation process. And note that since you have vicarious liability for subconsultants, you will be held responsible for them. And you should make sure that they will be responsible to you. I want you to have this and the next 3 images for your reminder, right? Keep this with you. This first one is to remind you that professional liability policies only defend policyholders, right? When you're discussing it with a client, you can talk about the limitations of a professional liability insurance policy. And this reminds you of the contractual liability exclusion that is in every professional liability insurance policy. Remember, your policy only covers your liability that is established when not meeting the standard of care for the services performed causes the harm. The legal term is liability in the performance of professional services. That means harm caused by negligently performed professional services. And one thing clients that understand professional liability and professional liability insurance will usually do is to make the contractual indemnification obligations track with the normal legal liability and the available insurance coverages. I mean, that only makes sense if they're requiring the insurance coverage to have the insurance coverage cover the risk that you're assuming by contract. That is, unless, of course, they are willing to go after your company and perhaps personal assets if they suffer a loss. Now, let's look at provisions that are extremely narrow, do not contain a defense obligation, and seem to be safe in almost every jurisdiction. The AIA finally added a generic professional services indemnification provision to the B103, which is for large projects, in 2007. It also included it as an option in B503, which if you don't have a copy of, you should get it because it's the free document that the AIA publishes that has modifications to the other standard AIA professional services agreements. That affirmative denial language highlighted was added for the 2017 version of the B103 and the B503. Now, when EJCDC first added a provision in 1992, it was reciprocal. And that's a good idea because a firm can be harmed by the negligence, gross negligence, willful acts, or other problems created by the client, especially if the client is a prime design professional. It was dropped from the EJCDC form because if you provide services for a government client, it is highly unlikely that a government client could indemnify a private entity. It opens a government client to losses it would never otherwise have because of its sovereign immunity. I mentioned we would not discuss other contracts, but you should know that both the prime sub agreement by EJCDC and by AIA have reciprocal indemnification provisions that are tied to the actual harm caused by negligent performance. So if you are in a sub-consultant's position, it makes sense to insist on reciprocal indemnity obligations. So what can you do when a client demands an indemnity and perhaps doesn't understand the difference between professional liability exposures and coverage and other liability exposures and coverage? It depends a great deal on whether the proposed client doesn't understand or just does not care. Now, you might try to argue against a broader intermediate form of indemnity or ask for reciprocity, only to find that your client or your client's legal advisor will state, I understand the difference and I don't care. I want more than your insurance at risk. If you are not willing to stand behind the services I am asking you to perform with your assets, I will find someone else who will. Now, in that situation, letting that type of a client find someone else is probably the best risk management strategy you have. But there are some other possibilities, and we'll look at four of them. A firm really can charge, right? If the client wants you to take risk beyond what you can control or insure, up your fee. Make sure the client understands and knows that you know that there is a cost for you to assume an indemnification obligation that goes beyond your normal legal liability, or a defense and indemnification obligation. You know, if they want you to become their insurer, if they want you to, if they want to be able to shift all the risks to you, charge them for that and make them understand that there has to be a charge. You have to set up your own risk funding allowance if they're going to transfer to you their risk. Or you can try to tie an indemnification to your insurance coverage. Your client might not realize that for professional liability insurance, no policy would cover the defense obligation. And therefore, if they agree to something that says to the extent covered by insurance required by this agreement, the client is essentially waiving the defense obligation. And you can try to at least make part of the contractual obligation match up with your available insurance coverage through a qualifying provision such as this. Or you can use language such as one of the next two slides to what is usually referred to as bifurcating the obligation in a clear way. You know, again, this one really tries to tie the obligation to your insurance policy. If your professional liability doesn't provide defense, and no policy does, you don't have that obligation. Now, this is a bifurcating of the obligation, and some developers and governments actually have separate contractual assumed obligations, a defense and indemnity obligation for instance, general liability situations, and an indemnity only for professional liability situations. We have examples from around the country. They are realistic and pragmatic and provide the client with an enforceable contractual obligation that tracks with normal liability and insured exposures. The advantage of adding to an indemnification obligation with a provision that clarifies the obligation in relation to third-party professional liability claims might seem less valuable than trying to edit an owner-generated provision. But with an owner-generated provision, you are highly unlikely to be able to negotiate changes in a way that your client won't object to. And even if you have a jurisdictionally competent legal advisor redline the provision for you, chances are you will still be at risk. And don't even think of having your insurance company redline it for you. Remember, the contractual provisions such as indemnity or defense and indemnity provisions are highly state specific. And every word probably has a precise meaning under state statutes or case law. So being your own lawyer or having someone not authorized to practice law in that jurisdiction provide recommended language is not prudent. So you can keep this language available, but it might not be responsive or enforceable in all situations. And here's another example of bifurcating the obligation. Keep this in your files as an alternative to discuss with your legal advisor when you see an indemnification that includes a defense obligation and an indemnity, or an indemnity that goes far beyond your normal legal liability in providing professional services. And I will leave you with this. Remember this when negotiating a contract. Liability in the performance of professional services is what professional liability insurance covers. That is harm to the extent the harm results from your failure to meet the standard of care for the professional services performed. Damages caused by your negligently performed services. Contractual liability exclusions are in each professional liability insurance policy. There is no standard professional liability insurance policy, but the elements are the same. And the exception is if there is no difference between your normal legal liability and your contractual liability. Otherwise, that contractual obligation is excluded. And you know what this really means, for example, is that with the CNA program, for instance, it will honor an obligation to indemnify and hold a client harmless that our policyholder gives to its client, provided that the obligation is limited to the extent damages, which under state law could include the client's reasonable costs of defending itself against third-party claims, have been caused by the negligent acts, errors, or omissions of our insured, and the indemnity is limited to the harm attributable to the negligence of our insured in the rendering of professional services for that client. So you should train yourself on the reasonable objections to a broad indemnity or defense and indemnity provision. You should be willing to accept a contractual obligation that tracks with your normal legal liability in the performance of professional services to correct harm caused by your negligent act, errors, or omissions. And you should find a local legal advisor who understands state statutes and monitors case law on the indemnification issue.